everyone. Good afternoon. A very warm welcome to the Comparative Public Law Research Forum. We are delighted to welcome Dr. Lewis Graham to deliver today's talk. Just to say a few words about Dr. Graham, first of all. So Dr. Graham is based at the University of Cambridge at Christ's College. He spent the previous 3 years at the University of Oxford. His research focuses mainly on public and administrative law, including human rights law. And he's talking to us today about judicial behaviour. He's published a number of empirical works on judicial decision-making in different contexts. And of course, Dr. Graham's book, Judicial Individuality on the UK Supreme Court, has been published by Hart this year. Hopefully, Dr. Graham can hold that book up, the copy of it at some point. Oh, there it is. Fantastic. So we're delighted, absolutely delighted to welcome Dr. Graham to give this talk for us. Fascinating insight into what judges are doing, how they're behaving, what they're doing when deciding cases. Just to say, there'll be time at the end for questions. So a message will be entered in the chat. So what you should do is, if you have any questions, please send your questions to me as the host or to one of the other co-hosts, and then I can read it out to I can read your question out to Dr. Graham. Great. Okay. Well, without further ado, then I'll hand over to Dr. Graham. Over to you. Thank you.
Thank you so much. Thank you for that very warm introduction. Thank you for the invite to speak to you all today. Thank you very much, all of you, for attending this talk, where I'll talk a little bit about my book, Judicial Individuality on the UK Supreme Court. Forgive me for being slightly embarrassing by having a copy of this book to hand. I've had it on my person pretty much since I published it, just in case I need to whack it out at conferences or impress upon certain people that they should buy it. So that's the book there. In today's talk, I'll attempt to answer 3 questions. Those questions are whether it's possible to observe and capture judicial attitudes on the UK Supreme Court. Secondly, whether the judges on the court approach different areas of law, including human rights law, differently from one another. And thirdly, whether and why the UK Supreme Court has become more conservative over time. Now, it is trite that on the US Supreme Court, we have different types of judges. We have liberal judges and we have conservative judges. When I was a student, the conservative judges were Antonin Scalia and Clarence Thomas. And the liberal judges included one very special, Ruth Bader Ginsburg. You'd come to a US Supreme Court case, see that the case was split, and hedge your bets on which judges would side with which parties. Ruth Bader Ginsburg would often side with the underdog, the dispossessed, the David against the Goliath. Antonin Scalia, with his firebrand originalism, would often adopt a more literal, arguably exclusionary approach to the law, one which was generally suspicious to grand claims about rights, often with a big dollop of deference to the executive. They have different kinds of judges in the US Supreme Court, unlike in the UK, of course. And then there's the Canadian scholarship, where you look at the scholarship and it says, well, if you look at judges on the Canadian Supreme Court, you can sort them into liberals and conservatives, activists and more restrained figures as well, unlike in the UK, of course. And there's literature from the South African Constitutional Court, showing there are progressive judges there too, and conservative judges there too. And in the Israeli appellate courts, and in other appellate courts around the world, we have different types of judges, just not on the UK Supreme Court, right? And yet, might we have different kinds of judges here too? That's the question I've been looking at since I was a PhD student. Ask any law student who studied in the UK, or anyone who's familiar with UK judges such as yourselves. Lord Denning was a very particular type of judge with his own views and own preferences and own approach to the law. He was a very different type of judge to someone like Lord Simons. Lady Hale, the feminist judge on the UK Supreme Court, was a very different type of judge to Lord Sumption. Lady Hale made it a big part of her legacy to improve equality on the Supreme Court, whereas Lord Sumption seemingly wrote a book arguing against equality in the 1970s. We might not use the labels liberal or conservative, although in the later part of this book, I do use the labels a little bit. We might use the language of restrained to describe some judges. We might say some judges are institutional figures. We might say some judges are comfortable expanding the law, certainly more than others. We might describe some judges as literalists and some as purposivists. We might do any number of these things. I suggest, therefore, we have different kinds of judges. This is what the book seeks to argue and evidence. My thesis, and by thesis I mean my grand argument rather than the 3 years I spent writing this in Cambridge, is as follows. It's inelegant, and philosophers can poke holes in its logic, but I thought since I'm in a room largely full of lawyers rather than philosophers, I can run it anyway. Here it goes. Step 1. Human beings necessarily bring their own personal preferences, ideals, values, and predilections to the decision-making process. Step 2, the controversial one. Judges are human beings. Step 3, therefore, judges necessarily bring their own preferences, ideals, values, predilections, etc. to their decision-making process. That doesn't mean that judges are entirely unconstrained. That doesn't mean that that the decision-making process is entirely dependent on preferences and values. It doesn't mean that every single judicial decision is entirely based on a judge's preferences, predilections, and values. But, I argue, given the room for judicial discretion in the law, and this applies to cases being decided by the UK Supreme Court and judges across the world, given the ambiguity in statute, given the open-textured nature of judicial decision-making, given the malleability of precedent, and so on and so forth, I suggest that judges' own values and preferences do affect their decision-making. That is my argument. I'm not the first to say it. I'm one in a very, very long lineage of judicial realists and judicial behaviorists who make various claims. But my argument is that this applies to the UK Supreme Court in particular. Now, to see whether this was the case in practice, I looked at every judicial decision handed down by the UK Supreme Court from 2009 onwards. I wanted to see whether case outcome data and data relating to case reasoning revealed or implied anything about the values of the judges deciding the cases. So whether certain judges would side with certain parties, or would tend to decide cases a certain way, or whether certain judges would use certain kinds of reasoning. My methodology was fairly simple. It's basically what Helen Tyrrell has called sophisticated counting. But if you do enough sophisticated counting, and you do them for enough cases, I think you start to see results. So when it comes to the UK Supreme Court, do we have liberal judges and do we have conservative judges? My answer is yes, at least some of the time. We can look, for example, at who sides with the state. Now, if you look at terms of pure numbers, and you simply count the number of times a judge sides with the state and count the number of times a judge sides against the state, and you line up the judges in order and you put them on a graph, you get a fairly even spread, around 50% as you might expect. Lord Neuberger sided with the state around 60% of the time, Lord Kerr around 40% of the time, and all the other judges falling somewhere in between. So at least when it comes to siding with the state, it may seem to be the case that judges don't bring their own strongly held personal preferences as to whether the state should be held liable. But, and it's a big but, if you look only at what I call salient cases, which are cases where judges on the same panel disagree as to the approach to take regarding the state, something interesting opens up. So I'm mainly here looking at cases where you have, say, 5 judges on a panel. The judges have to determine whether the state is liable for one reason or another, and 3 judges say yes and 2 judges say no, or something like that. Now, if you look only at those cases, Lord Brown, who sadly died a few months ago, known for being a more conservative judge, colloquially, he sides with the state in over 80% of salient cases. Lord Hughes and Hodge, 70% of salient cases. Contrast that with Lady Hale, who for a long time was the only woman on the UK Supreme Court. Just 25% of salient cases did she side with the state. And Lord Kerr, just 20% of cases. That's a big difference. Now, there are so many reasons why these figures might be the way they are. Maybe Lords Brown, Hughes, and Hodge just sat on lots of cases where the state's arguments were stronger. Maybe Lady Hale and Lord Kerr sat on more cases where the case against the state was, where the state was stronger. Maybe Lady Hale and Lord Kerr sat on more cases where the case against the state was stronger. We don't know. Well, I don't know. You can't tell that just from the data. And there are a whole host of other factors, but the figures I suggest are stark. And if we match this finding with other findings, we start to reveal consistent patterns about judicial behaviour. So I looked at the underdog dimension. That is, did judges systematically side with weaker parties? And again, when we look at salient cases, those cases in which judges sit on a panel disagreeing with one another, we get some stark results. Lord Hughes and Neuberger would side with the underdog in just 20% of cases. Lord Hodge would side with the underdog in just 10% of salient cases. A caveat here, there wasn't a lot of data for Lord Hodge. There were only about 10 cases, but still 1 in 10 cases. By contrast, there were 2 judges who sided with the underdog in over 70% of cases. Those judges were Lady Hale and Lord Kerr. Both had what I call a strong underdog preference. Now, does that mean that Lord Hughes and Lord Hodge were consciously and intentionally deciding cases that favour a stronger institutional party? Did Lady Hale and Lord Kerr set the law to one side in order to favour underdogs? Not at all. These judges have different judicial philosophies. And in the margins, the really hard cases, the cases that go to the UK Supreme Court, there are really tough questions about exactly how discretion should be exercised, how much benefit of the doubt should be given to the state, what kind of arguments ought to win the day, all legitimate legal and judicial questions, and judges answer them in different ways. One more example. This one's my favorite. I looked at how often judges would side with parties that argued that there's a breach of the ECHR, that is, the European Convention on Human Rights, the document that the UK has signed up to and which our Human Rights Act brings into force domestically. So basically, we have the human rights documents, and I looked to see which judges said there was a breach of human rights standards and which judges said there was not a breach of human rights standards. And again, I looked at salient cases where judges differ as to whether the ECHR was breached on the facts while sitting on the same panel. Lords Hughes and Brown adopted what I've called a pro-human rights position in fewer than 10% of cases, less than 10% of cases. Lady Black and Lady Hale adopted, 2 women on the Supreme Court, the only 2 women on the Supreme Court for a long time, would adopt a pro-ECHR position in more than 70% of cases. And Lord Kerr, who was a judge who sided with the underdog and sided against the state in the stats that I mentioned earlier, remarkably adopted a pro-human rights position in 94% of cases. In fact, there were only 2 cases in which he did not adopt the most human rights friendly stance, and in both of those cases, the most human rights friendly judge was Lady Hale. Now, does this mean that either of these flanks, the high percenters or the low percenters, were not doing their jobs properly? Well, they're putting the law to one side in order to systemically side with a certain party or against a certain party when it came to human rights issues. Not at all. The interpretation of the ECHR, like any human rights document, is a contested judicial topic. Should rights be given a narrow, cautious, literal meaning, or a wider, liberal, living instrument style meaning? Should states' justifications for breaching rights be accepted readily or treated cautiously? These are legitimate judicial questions, and a judge's legal philosophy will help to determine the answer. So in a later chapter of the book, I think chapter 9, I do have a go at bringing some of these trends together into judicial profiles. So I say, for example, that Lady Hale and Lord Kerr appear as liberal judges. I say that judges like Lord Sumption and Lord Hughes appear to be more conservative judges. I say that certain judges, there's a judge called Lord Dyson, appears to be quite anti-institutional. He's happy to question the state, he's happy to develop the common law, but he's less comfortable with finding breaches of human rights compared to judges like Lord Kerr. I find that other judges like Lord Hope are pro-institution. They're very institutional, they're wedded to the executive and the legislature, but in other areas appear to be more activist. So I draw together some profiles. If anyone has a favourite judge on the UK Supreme Court and wants to hear about their profile, please let me know. But I want to move on to my third point, that the UK Supreme Court is becoming more conservative over time. And by over time, I broadly mean from around the year 2020, we're moving towards a more conservative Supreme Court. Now, I'm not the only one to mention this. In a blistering essay, and I really do recommend that you read it if you have a spare 10 minutes, Professor Conegati of the LSE attacked the Supreme Court's commitment to formalism and conservative approach to the law. He goes through some recent cases decided by Lord Reid and other judges and shows how they are a move to the right, a move to a more restrained approach. Adam Tompkins has noted the court's more conservative approach in recent years. Richard Eakins of the Judicial Power Project has noted, and in fact has praised, the court's more cautious and more disciplined approach. And Lord Sumption, who retired from the court a few years ago, has noted that the court has operated in a more restrained way, which pushes back against some of its earlier judgments. And when you look at the statistics, we do find that there's evidence for all of this. Take, for example, human rights law. Before the year 2020, the success rate of human rights cases averaged around 41%. So 41%, in 41% of cases, the human rights claim would succeed, about 4 in 10. In 2019, it was 60%. So out of 100 cases, 60 would succeed. Now, between 2020 and 2022 was the last year in which I had data for the book, but I've looked at more data since, we actually see that the success rate of human rights claims went down to just 29%. So down from 60 in 2019 to 29 between 2020 and 2022. In that period, the court issued no declarations of incompatibility saying that there were any breaches of human rights law when it comes to primary legislation, nor did it use Section 3 of the Human Rights Act in any reported case, but for a case called Ziegler. The court has also taken a narrow approach to common law rights, to the principle of legality and the Human Rights Act, for the need for rights to be prescribed by law and to other rule of law issues. All of this is to say, I think when you look at the stats and when you read the cases, it's true that there's evidence, quantitative and qualitative, that more recent court judgments, more recent UK Supreme Court judgments, have been more restrained and conservative in nature. This is true of human rights issues, but I argue it's true in other contexts as well. So why is this the case? That's the big question. The stats can show us the data, the stats can show us the trends, the stats can't tell us why there's been a move to a more restrained position. Some commentators, not me, have argued that the court's judges have become sort of afraid of politicians in recent years. There was a lot of backlash after some famous judgments, Miller 1, Miller 2, the Brexit decisions, and some other famous cases where politicians heavily criticised the Supreme Court and threatened it with reform or abolition. And there's an argument that in response to that critique, the judges are stepping back and are being more cautious and more careful and more restrained, more deferential to the executive, less likely to hold that they're breaching human rights standards. So were the judges simply retreating from these attacks? I don't think so. In line with the rest of my book, perhaps unsurprisingly, I argue that the answer here has everything to do with judicial personalities. I mentioned earlier that we have some conservative judges and some liberal judges and some judges that fall in the middle. Right now, as of 2025, on the court, if you look at the judicial personalities sitting, I don't think we have any strongly liberal figures. We don't have a Lord Kerr. We don't have a Lady Hale. We barely have a Lord Wilson or a Lord Phillips, two other broadly liberal judges. Instead, the current crop of judges are either relatively restrained or conservative or fall in the middle. And that, I think, forgive me, I'm working from home and there's an appliance in my kitchen just beeping. And that's, I think, is what explains the court's current restrained approach. Judicial personalities, conservative judicial ideologies. Now, is this a good thing or is this a bad thing? Can this be changed? Should this be changed? Is there a way to make the court more balanced? All of these are tantalizing questions, and I raise some of them in the last chapter of my book. But I will leave those questions for someone smarter than me to answer, and I will leave them for you to ponder upon. Thank you very much for listening to my presentation. That's all I wanted to go over this morning. I'm happy to discuss or answer any questions that you might have. Thank you very much.
Wonderful. Thank you, Lewis, for such a fascinating uh, talk and survey of some of the issues in relation to the UK Supreme Court in particular. There's been a lot that's been written about, as you said, about other courts, notably the US Supreme Court. But this was a fascinating insight into the UK, and also just more generally, just thinking more reflectively, more deeply about judicial behaviour. Now, let me just just to remind everyone, if you I'll just type a message in the chat. If you have any questions, you can send them to me directly. So I have a bunch of questions. I might just kick off just to get things going. One thing that interested me, and I think you discussed this in the final chapter of your book. You were in that final chapter, as you mentioned, you were talking about looking ahead, what to do, what should be done, assuming that we accept or on board with the thesis, the argument that you've presented about judicial behaviour. And one of the considerations that you raised was this issue of authority, the authority of judges. So there's all this discourse, rhetoric about judges being impartial, neutral decision makers. And what you're suggesting is, well, look, that's something that we need to rethink, we need to push back on. And what you raise in that final chapter of the book is this concern that perhaps some of the judges might have, and others as well, that the reason why we might have this discourse about judicial neutrality is so that judges can be authoritative decision makers. They're dealing with highly fraught community disputes, some of these can be very difficult disputes involving the state, the government, of course. And so to help aid the resolution of these difficult problems, we need this sort of rhetoric, as it were. I mean, I suppose you're pushing back on this through the book, right? You're saying, look, actually, there is a lot going on here in terms of judicial personalities and preferences and so on. So I guess my question is, in terms of what should be done, clearly your intervention here is inviting us as observers to recognize that actually judges do have their preferences, their political preferences, and so on. Do you think that the judges themselves they have a responsibility, either in their speeches in decisions or extrajudicially? Do you think that they have a responsibility to be more transparent about some of their preferences? Thank you.
Yeah, it's a great question. Thanks. It's also a really difficult question because my mind sort of changes on this issue a little bit from time to time. There's this wider question of, do we need the myth? Do we need the vital lie that judges are impossibly neutral? Again, I'm not arguing that judges are not relatively neutral or relatively impartial, or to an extent where it matters impartial, but absolute Olympian impartiality. Do we need that myth? And you're right. I put it in the book that we can do with accepting the modest truth. It's a modest truth that judges are, to an extent, creatures of their own personal predilections and things like that. But since they always operate within a band, since they always act legally and use legal discretion and judicial discretion, I argue that the effects of judicial independence, independence is an important thing, but judicial partiality rather than impartiality shouldn't be overstated. So that's one sort of aspect of this debate we need to remember. Do we need the myth? I don't know if we do, especially given how modest the reality is. But as to whether judges should, I suppose, play up the myth of absolute judicial impartiality, I mean, again, doing an annoying academic thing where I'm not quite answering your direct question, I'm answering a question that I feel more equipped to answer. Do we need this myth more generally? Well, I think people like Joe McIntyre, Erica Rackley, Linda Mulcahy have looked at this myth of judicial impartiality and have said, actually, we don't need to uphold it, even for its kind of myth-making benefits. So the authority of judges, well, that comes from judges being perceived as being fair, judges being transparent, judges acting within a reasonable band rather than absolutely neutral. And so would it be imperative on judges in their extrajudicial speeches and as part of their reasoning to expressly draw upon their predilections and preferences? I think it's a really interesting question, and I think it could be beneficial. What I wouldn't want to see happening, I think, is for judges' predilections and preferences and values and biases, or whatever you want to call them, being used as a metric upon which we judge them as to whether they're suitable for office or not. This is what happens in the US, right? You have these hearings where judges have to agree with the president's or the party with the majority in Congress's political views. You have to show that you're a conservative judge to be appointed by a conservative party, or you need to show you're a liberal judge to be appointed by a liberal party. I think that's quite dangerous for a whole host of reasons. And I think we should avoid going down that particular route. So possibly, yes, judges could do with being a bit more honest about their own personal preferences and what they're bringing to the courtroom. Erica Rackley makes a great argument here about how this will help with diversifying the judiciary and bringing more perspectives into the courtroom, and we can only do that if we're honest about it. But I wouldn't like to see that being translated into a requirement for appointment.
Great, thank you. Um, it's yeah, I have a bunch of follow-up questions myself, but I'm going to we have a whole set of questions in the chat. I think I
Sure.
count six, seven, etc. So I'm just going to get into some of these.
Yeah, sure.
So hopefully I get these in order, but my apologies to people if I get people out of order. So as I say, six, seven, eight questions that have come through. Um, First of all, from a colleague, Professor Yueming Yan. I don't know, Yueming, if you want me to read this out or whether you want to um, uh, say this, speak this question, discuss this yourself. I can read this out. Oh, not allowed to speak. Oh, she's been muted. Okay, I'll read this out. Oh, actually, let me just. Sorry, would it be possible to unmute Yueming Yan? Or actually, better, I just read this out. Actually, it might be quicker. Okay, so Yueming says, Professor Yan, she says, great presentation. Uh, I have a question on how the speaker categorizes these judges using conservative or liberal, those categories as an example. What parameters are used? For instance, are the judges self-claimed as liberal or conservative? What are the sort of references? What are the criteria relied on? Thank you.
Yeah, another great question. I was skeptical from the outset of the language of conservative and liberal in particular, and labeling in general. I found that if you wed yourself too strongly to these labels at the outset, it can affect how you're doing your coding and categorizing. Um, so basically, instead of looking at one overarching question, conservative versus liberal, or one measure, conservative versus liberal, I focused on 14 separate measures. So they're the sort of the micro questions of does a judge side with the state? Does a judge side with human rights law? Does a judge do this? Does a judge do that? And then afterwards, I sort of compiled them and said, well, based on the existing political science literature and judicial behavior literature, can any of these measures be fairly described as liberal or conservative? So, for example, on the specific liberal and conservative dimension, I looked at whether a judge sides with the underdog, whether a judge sides with the state, whether a judge sides with the human rights claimant, and a couple of others. I used other measures such as activist and restraint. And for activists, I use things like whether the judge departed from precedent, whether a judge adopted a wide approach to statutory interpretation, whether the judge was likely to find that there was jurisdiction in the case, and things like that. So it's a very, to use a term that my political science friends would hate, wishy-washy definition of conservative and liberal, and I use it in a descriptive sense rather than an absolute sense. So I use it in the chapter later in the book where I'm talking about judicial profiles rather than bringing them in at the beginning. But yeah, for conservative and liberal, it's mainly siding with the state, siding with the underdog, and siding with the human rights claimant. The question as to whether I use or care about whether judges have sort of self-claimed any judicial identity is really interesting because most judges have not. Most judges on the UK Supreme Court, quite understandably, have not described themselves as any of these things. There are some exceptions, two or three exceptions, because some of the judges had different careers before coming to the bar, where this kind of no barrister would want to describe themselves as conservative or liberal because it might affect what kind of cases they might get. But some people like Lord Sumption was an academic for a while and then was a barrister rather than and was a historian and wrote a book. Like I said earlier, wrote a book on equality and had a different background. And he did say that he identifies as a conservative thinker. So, interestingly enough, where judges have described themselves as conservative or liberal, that has matched with the data. I haven't found an example of a judge who says, I'm really liberal, and actually they appear to be really conservative, or vice versa. But for most judges, there's not that self-claimed label to attach.
Wonderful, thank you. So pressing on through, as I say, a whole bunch of questions. So if I, again, just proceeding in order of how I received them. So another comment here from, I'll read this username out, B165181, saying, thank you, the talk was wonderful. I'm wondering whether the conservative character of the Supreme Court aligns with societal change. For example, that they're asking the judges in terms of how they're appointed. Are they being appointed because their personalities align with society? And in other time, or going on also to say, asking about perhaps in other times judges being appointed, being more liberal, again perhaps being connected to society as well. Thank you.
Yeah, that's a great question. I'm going to chicken out and say I don't really know. I don't really know. I think there is, because society is so wide, right? Society, determining whether society is more conservative or more liberal is difficult to diagnose. Whether the prevailing legal milieu, the prevailing political nature of legal society, lawyers and barristers and judges, has become more liberal is an interesting question. I think that possibly might be the case. I think there was some discomfort with some of the more, let's say, progressive judgments of the mid 2000s. I think there was some discomfort with some of the European Court of Human Rights' judgments on prisoner rights and prisoner voting and prisoner sentences. I think there's generally some societal backlash on the idea that, prisoners should have rights and immigrants should have rights and terrorists should have rights and all of this kind of the universalism of rights argument. So I think there might be something there. I think the legal milieu has become slightly more restrained and conservative. And it'd be interesting to diagnose whether UK society or, society in general has become slightly more conservative over time. That's a great question. And I'm not sure if I know, I'm not sure if I feel qualified to answer it in full yet, but it's a great question. One to think about.
Brilliant, thank you. So another question, this from another colleague, Professor Ryan Mitchell. So Ryan asks, the data that you examined, did this include party membership or socioeconomic background? If so, are those indications dispositive? And Ryan goes on to ask, how do these factors, those considerations, interact with the notion of individual judicial personality?
Yeah.
Such. Thank you.
Yeah, there's some literature which looks at this in the US, Canadian, South African context, where they look at sort of the backgrounds of judges and try to say, well, does going to a certain type of school, does going to military service, does coming from a certain socioeconomic background affect the way you judge? And most of the literature says, well, it's imperfect, the correlation is imperfect, but broadly the answer is yes. If you have come from a background where you're used to seeing how, socioeconomically deprived constituents are affected by welfare cuts, and then 40 years later you are judging the constitutionality of a welfare cut, you're going to bring that experience to the courtroom with you. I haven't done that for this project, and there's a couple of reasons why. The first, I think that the most obvious one actually is that UK Supreme Court judges have a fairly homogenous socioeconomic background. They're all wealthy in a previous life, even if they claim sometimes not to be too wealthy on their judicial salaries now. Although looking at my salary and then the judicial salaries, I think I'd know which one I prefer. Um, they were all almost all practicing barristers, or in one case, a solicitor, for a very long period of time, doing very high-profile cases. Lord Sumption was earning millions and millions in his practice. Um, they are, until very recently, all white. They are almost all male. They are in a very comfortable socioeconomic bracket, meaning that sort of it'd be really hard to sort of divide up the judges socioeconomically. Um, that's just on the Supreme Court. There is more diversity in the UK as you go down the ladder, I suppose. You start to look at magistrates and county court judges and high court judges, you get more diversity, including probably diversity of socioeconomic background, which means that that kind of question will be really interesting to look at there. But for the Supreme Court, there's just not enough diversity. There is somebody, and I can pass on the details, someone called Claire White, who is doing a study on whether the ostensibly neutral language of UK Supreme Court judges actually reflects the fact that they come from a privileged socioeconomic background, whether there's a correlation between to put it bluntly, the privilege of judges and the language they use in their judgments. And I think I've spoken to her, and her claim is pretty much you can tell that there's not much diversity, socioeconomic diversity on the court. And as to party membership, again, we don't know the details. There's only one judge who's really said that he was a member of the Conservative Party. In the past, judges were much more open about this, and in private conversations with judges, I've spoken about their party membership, but they are not having that put on the record. So there's no way I'm going to be able to draw upon that in data.
Great, thank you. So another question, this is from Martin Lee. He asks, is your data classification methodology applicable in contexts outside the UK Supreme Court, for example, to judges in lower level UK courts or courts in other jurisdictions? And he goes on to ask, is any tinkering needed? Are there any possible limitations? Thank you.
Yeah, good question. I hope it's not copy pastable, because I designed the methodology and the data classification and the operationalization matrix in such a way that it was unique to the UK Supreme Court, because I wanted it to work as well as it could. So I hope it couldn't just be copy and pasted. I hoped it could be tinkered or tweaked to apply in other courts. When I was designing the data set, when I was designing my methodology, my data classification, I drew upon and was influenced by studies in other courts. So I think it's similar to, but distinct from, approaches that other scholars have taken. It's really interesting that you ask, could this be applied to lower courts? Because the project that I'm doing now, sort of my follow-up project on this, is to look at judges in the administrative court. And the reason I focused on the Supreme Court for this book was because you have not many cases, about 80 a year, but those cases are all very interesting. Whereas with the administrative court, the High Court, the first level court in the UK for administrative law cases, you get a load of cases, thousands of cases, but they're not all really interesting. So I guess I'm sacrificing depth for breadth. And I have used a similar-ish methodology. I've certainly used sophisticated counting to try and track judicial behaviour and other trends on the administrative court. So I think it can be done. I think it could be applied to the Court of Appeal or criminal courts or human rights tribunals and things like that. If you're really interested, I have a methodology chapter in the book. And I think it's not quite as thorough as it was during the PhD, because for the PhD I was terrified of failing my PhD, so I made sure my methodology chapter was about 100 pages long. But the methodology chapter in the book does sort of detail how I did this sort of work, and hopefully it should be generally applicable. If not generally applicable, at least transferable to other contexts.
Brilliant, thank you. Another question here from Will Wu. I have a question for the presenter. To study the personality of UK Supreme Court judges seems very American. as they the American judges were appointed politically.
Mm.
And so he asks, I wonder if the book is inspired by similar studies in the US. Thank you.
It is, yeah, it is. And I think there's two things to say, well, with comparisons to the US is one, I haven't found that our judges behave like US Supreme Court judges. Um, I've found that our judges are more like US Supreme Court judges than we've perhaps previously admitted, but that there's still a big difference between the strictly ideological nature of judging in the US Supreme Court and the sort of semi-ideological nature of UK Supreme Court judging. But yeah, I used the US studies, I used the Segal cover score methodology, I used uh, Lee Epstein's methodologies in some of that work. I was really influenced by the US literature and methodology. Yeah.
Great, thank you. Another question here from Utree Springleaf. This is getting into some detail here about areas that I think are not quite in our expertise for both of us in contract. But so the question is, Lord Denning, taking Lord Denning as an example. So thank you for the interesting presentation. Taking Lord Denning as an example, his endeavour in promissory estoppel brought an uncanny
Mm.
amount of clarification in the case law afterwards, as it touches on consideration. Do you agree that this is a potential reason for a contemporary judge to refrain from such kind of clarification and being more conservative, as you've mentioned? Thank you.
Now, with the caveat that it's been about 13 years since I last had a serious thought about consideration um, or promissory estoppel, um, I've passed that teaching on to colleagues rather than doing it myself. Lord Denning's a really interesting example because Lord Denning did have a an effect on his contemporaries. You know, you see in the House of Lords, you see Lord Simons saying essentially, "Don't be like Denning. It's our job to not do a Denning." And you see later judges, even those that quote Denning with approval and cite him as one of the greatest judges of the 20th century or whatever, saying this is something we need to be very careful about doing. This sort of lackadaisical approach to methodology, the sort of weak approach to precedent, um, for lack of a better word, disrespect for hierarchy, freewheeling approach to certain common law doctrines. Um, I think it probably has had an effect on contemporaries and later judges. I'm not sure they're saying that expressly, but certainly. So this doesn't answer your question, but apologies, it'll all come together in the end, I promise. There was recently a hearing before the UK Parliament, and there was a committee, and Lord Reid, who's one of the Conservative members of the current Supreme Court, said something along the lines of, "You guys don't need to worry. We're not going to be like certain judges of the past." Now, I wasn't talking about Lord Denning. He was probably talking about Lady Hale and Lord Kerr. But the fact that you have some judges who sort of leave pasture and put themselves out there and push the boundaries a little bit probably does have a rebound effect on other judges, where they'll say, "We're not going to do that. We're not going to emulate that approach. We're not going to be so activist and liberal." So I would not be surprised if Lord Denning's liberalism, and he was only liberal in certain ways. He didn't like trade unions very much, for example, but his liberalism in certain respects probably had an effect on later judges. Yeah. I think that's all I can say without really getting into the details of consideration, which I really don't want to do because everybody in this room knows more about consideration than I do.
Well, I think you probably know more about consideration than I do. I'm sure I'm the most ignorant on that. Another question from Cliff. Is there evidence the UK government, or whoever makes these decisions, so I suppose the Commission, is there evidence the UK government would favour promotion of conservative Court of Appeal judges, etc., to the Supreme Court? If so, do you think Court of Appeal judges hide their liberal views,
Mm.
wishing that there would be promotion for them. Thank you.
That's a great question. So we have the government doesn't appoint judges directly. The Judicial Appointments Commission appoints judges, and the Judicial Appointments Commission is an ostensibly neutral body, but the UK Supreme Court President sits on the panel, and so do certain other judges. So on the one hand, maybe one answer is just to say no, it doesn't matter because an independent panel does the appointing. Well, I think two things to be said to that. One, the independent panel, who's sitting on it? Well, the president of the UK Supreme Court, and who is the president of the UK Supreme Court? Lord Reed, quite a conservative figure. So his view of which judges ought to be appointed probably matters. He has been on record as saying he essentially will bear in mind judicial temperament when it comes to appointments. He said that to the House of Lords committee. And yeah, I've often thought about this. If would slightly more liberal judges sort of hide their colours a little bit? I'd hope not. I'd hope not, because I'd hope that the Judicial Appointments Commission is neutral enough to appoint good judges of all political stripes. I'd hope that the benefit of being a liberal judge, I say this as someone who's probably a liberal myself, having a more liberal disposition on the Court of Appeal is probably a good thing because, like, Lord Denning was on the Court of Appeal for what, 20 years? He found that a more influential site than the Supreme Court House of Lords. So I'd hope that those potential appointees wouldn't hide their colours. As to whether they actually would on the boundaries, I'm not sure. It's an interesting question. Possibly. Possibly.
Great, thank you. Another question here. So there are a few more questions. I think some that have come through to Cherry as well. So another question here from Raymond Ho, who says, Dr. Graham, thank you for your presentation and the new book. In your 2023 article, Liberty and Its Exceptions, you concluded that the nature of judicial reasoning, so long as it is conducted by human beings, may render this practically inevitable. Indeed, as has been shown, even the very precise closed list of exceptions in Article 5 has been in the end no match for judicial ingenuity. So I guess referring to the European Commission. Are the main arguments in the book a confirmation of this conclusion in the article? Thank you.
Yes, sorry, you know what this is? Actually my washing machine, which which I forgot to turn off before this meeting. So apologies for the
That's fine. Thank you.
Working from home. Yes, well, thank you for reading the article. I really like the Liberty and Its Exceptions article, and I think my conclusion probably does square up quite nicely with the findings in this book. In that article, I essentially looked at the exceptions to Article 5 of the ECHR, right to liberty, and I concluded that there was this sort of judicial flexibility going on. So even in these very technical areas, we don't. I don't know about. I don't know how much anybody here knows about the right to liberty. But we don't even teach the right to liberty in our human rights course here because it's so technical and knotty and really boring. I find it really interesting, but certain people find it quite boring. It's a very technical right, very technical article, and yet judges still use ingenuity and flexibility to read in exceptions that are not really there. And you see these divisions on the court where the majority and the minority are kind of pulling in different directions. So yeah, I think the two are consistent. I think judicial ingenuity might be a sort of a synonym for judicial flexibility, judicial malleability, judicial discretion, and of course personal preferences, predilections, and values all feed into that. But thank you for reading that article. I'm glad someone's reading it.
Brilliant, thank you. A few more questions. So a couple that Cherry received that I'll just read out. So the first question Do you think the change in judicial personality on the UK Supreme Court and the resulting increasingly restrictive interpretation of laws will have a widespread impact on the development of law, particularly human rights, in other common law jurisdictions, given that judges in those jurisdictions may also interpret their laws by reference to English law? I understand that judges' interpretations in those jurisdictions are likely to be influenced by local politics and the composition of their own courts, but I would be grateful if you could shed light on whether this is a possibility and whether it could lead to a slower development of human rights law in common law jurisdictions. Thank you.
Another great question, and another question that I'm going to have to sort of say my expertise doesn't extend really to a sophisticated analysis of sort of common law jurisdictions in the last few years. But I can tell you two things. Well, I'll tell you three things, one of which is speculative. One, I'd instinctively suggest that the answer is yes, because for better or for worse, the UK Supreme Court is influential in common law jurisdictions. And if the case law, the landmark cases at least, have been almost universally restrained, that's necessarily going to have an approach for when it comes to persuasive precedent in other jurisdictions. So my instinctive answer would be yes. I can give you two sort of more specific thoughts. The jurisprudence of the European Court of Human Rights has taken note of some of the UK Supreme Court recent jurisprudence, and that has resulted in what I would argue is a more restrained approach at the European Court of Human Rights. And also, there have been a couple of citations of big cases. There's a case called SC, which concerns welfare benefits. And that case has been cited by courts in Ireland, in the Republic of Ireland, and has been sort of quoted with approval. So there's been an effect in Ireland as well. So I wouldn't be surprised if there was a knock-on effect in some other jurisdictions.
Thank you. Another question here that was sent to Cherry. Do you think the UK Supreme Court's decision in For Women Scotland and Scottish Ministers 2025 is further evidence of this change in judicial personality? So the sort of gender recognition, gender certificate issue.
Has to necessarily be my own personal view. I have read and synthesized and reflected on the judgment. I think if the court simply gave the first half of its judgment, which was essentially a statutory interpretation exercise, which said that sex under the Equality Act must mean biological sex, I think we might have seen that judgment before 2020. What is really interesting to me is the later paragraph of that judgment, where the court cites with approval some of the interveners, sex matters, and things like that, where the court talks about the dignity of lesbians and things like that. I think that's going in quite a conservative direction. I think it's an activist decision because the court is going against lower courts, is overturning certain case law, is talking about these wider issues relating to the dignity of lesbians in sport and lots of obiter dicta. So I think it's an activist decision. But I think all this talk about protecting the dignity of lesbians, what to me is a talking point of the gender critical sex matters organization, is showing that the court is acting in a slightly conservative way. So for me, that probably is an example of the court not behaving in a restrained way, because that's quite an activist decision, but probably quite conservative overall, yes.
Wonderful, thank you.
Obviously, many other opinions are on that case in particular, many opinions are available.
Yeah, absolutely. Yeah, yeah. Great. One final question, I think here. I'm really sorry, I'm going to butcher this name. Sujun Guan, I think. My apologies if I've really messed that up. So the question is, judgments, judicial decisions, reasoning take place on the basis of submissions from barristers on both sides, how much judicial innovation originates from the judges themselves and how much from the barristers making the written submissions and oral arguments? Thank you.
Yeah, that is a really good question. That is a question that I've been struggling with for a long time. Because you're right, if the barristers in the case are presenting option A or option B, and both of those options are, say, necessarily conservative or necessarily liberal, then the judges don't have much leeway as to which direction to go. Um, all I can say is that it probably does matter. I don't think it overrides judicial personality, judicial discretion, judicial power, but it probably does matter. Now, that's why at the beginning of the talk, when I said, Lord Kerr sides with the state in X% of cases, and Lady Hale in X% of cases, and Lord Hodge in X% of cases, that's only correlation because there may be lots of other reasons as to why judicial decision making is going one way or the other. And the submissions to the court will be an influence on that. I just think that when you put all the stats in line and you look at, you know, Lord Kerr siding with the state in 80% of cases, siding with the underdog in 90% of cases, siding with human rights claimants in 94% of cases, you start to see that the correlation is so strong, you can infer something about judicial personality from it. But I still think you're right. Submissions are another piece of this puzzle. Submissions are a piece which I haven't quantified in the analysis and are probably doing, at minimum, some work in determining judicial outcomes. So it's a good point. Thank you for raising that. It's a weakness of the project.
Wonderful. Thank you, Dr. Graham, for what was a really fascinating discussion. And you can sort of see from all the questions that we received that it was, I think the audience were absolutely fascinated to hear from you and hear about this project.